enforcement update. Take it away, Paul.
All right. Hi, everyone. Good afternoon. Thanks for being here. I won't keep you too long. It'll be another quick 30-minute session talking about privacy and cybersecurity enforcement. Particularly in the US, we'll focus on that and as it relates to technology, especially in the medical space, but we'll discuss some other related enforcement activity. A little bit about me. My background is in privacy and cybersecurity, compliance, and I've been practicing at Gardner, focused on those areas as well as AI and technology. So we'll skip right past my bio and we'll get into this. So to kind of frame the discussion, I'm not going to dig deep into the legal standards. We're going to focus on what is the Federal Trade Commission, what is HHS, and the OIG looking at in terms of HIPAA enforcement. We'll look at a few states and how they're regulating and enforcing privacy regulations. And then we'll also take a quick look at some GDPR-related enforcement, particularly around med device, but also some of the broader trends that we're seeing in terms of enforcement. And I asked the question, hot or cold, to start off. I really think enforcement, maybe it's not hot at this point, but there's certainly some movement. I think clients ask us often, is this really being enforced? Is there really activity around this? Isn't it just the large organizations that are seeing enforcement? And I think the answer you'll find today is it is an active area, growingly active, especially in terms of state law enforcement. Whereas federally and internationally, it's already been a pretty active area. So let's start off with a HIPAA example. So generally speaking, HIPAA is a regulation that applies to what are called covered entities and their business associates. Through those laws, the government has the ability to bring actions through violations that are cybersecurity related, so failures to address security rule requirements, and privacy rule requirements which relate more to the use of information and how certain rights are addressed for patients. So in these examples, and we'll start with this one from Warby Parker, there are various kinds of violations that are highlighted and cited by HHS in their enforcement activity. And then along with that, there's typically a settlement. So in this case, we have a $1.5 million civil money penalty that was enforced against Warby Parker. And at issue in this was an ongoing data breach issue that developed over a number of years. And essentially what was happening is what's called credential stuffing. So this is a kind of attack where passwords and other credentials are taken from typically maybe another data breach, and then those credentials are used to attack a website, for example, where there's a login and access those accounts. So Warby Parker was aware of this activity for a while and had been investigating it and kind of looking at it. But eventually, when they submitted a breach report, HHS looked into it further and determined there was a few different areas of failure. And one of those, of course, was risk assessment. That's a common issue. So a good risk assessment involves looking at all of the electronic PHI in the systems that the protected health information that the organization is processing and evaluating where are the risks. And like the risk of dropping this clicker as I'm talking, but where are the risks and identifying those and then addressing them and documenting all of those activities. So one of the highlights here is that there was a lack of risk assessment for ePHI. And of course, along with that, well, if you haven't done a proper risk assessment, you're naturally going to have insufficient security measures, and then from there, potentially breaches and other issues. So this was a recent case that illustrates, in the medical device supply area, a gap and ultimately some enforcement activity. Another area, this is a business associate example where Health Fitness Corporation, this business associate that was providing services to a healthcare provider, a covered entity, they had a corrective action plan and enforcement around $227,000 civil money penalty. Between those two things, a sizable amount of activity to address the issues that were found, and also a financial impact directly. And what was at issue here is again, there was a lack of risk assessment awareness of particularly how security controls were implemented, at the organization, and that led to a publicly accessible server, which should not have been publicly accessible, to be clear, that was available through the internet, so web search crawlers, those kind of things that Google uses to develop its search results, found this server and then cataloged the data within the server. And so that obviously is not a secure way to maintain PHI, and that led to this particular breach. And that also, of course, leads to penalties and potentially litigation and all those associated issues. We have another issue, or another scenario here, where a medical supply company had, again, a volume of PHI that was being stored within the servers. And this particular one I think is really interesting because there was such a large potential volume of data involved, and it came from something that we're all familiar with, a phishing attack. So as you know, phishing is a type of targeted attack where emails, or in some cases it's text messages, are used to attack a particular organization. Maybe it's more sophisticated now, especially with the use of artificial intelligence. But that essentially, through one of these phishing attacks, we don't have the exact details of that attack, credentials were provided that led to the breach of a significant amount of data. What also is interesting about this is the resolution agreement included 2 years of monitoring. So not only is there this significant settlement penalty, but also some direct enforcement and monitoring will continue for a couple of years after the settlement agreement. So we're going to shift a little bit. So HIPAA, of course, is a major part of enforcement, but also the Federal Trade Commission federally within the US is focused on all of really any sort of commerce. They're regulating that in terms of various fairness issues, and particularly in the privacy and cybersecurity space, they're looking at what are called unfair and/or deceptive trade practices. And that's regulated under Section 5 of the Federal Trade Commission Act. And again, the focus here is how does a company's activities when it relates to cybersecurity, the adequacy of that, could that be an unfair practice, and whether that leads to a breach or other potential misuse of information, that could potentially be an unfair trade practice, or the use of, say, information internally or through disclosure, especially sensitive information like health information that you might see at a manufacturer or other kind of health app or organization that offers healthcare services. The FTC is really focused on those kinds of activities and how might they be unfair or deceptive. And along with that, while the FTC could, in theory, regulate HIPAA-covered entities, what they're really emphasizing in their enforcement are those entities that fall outside of HIPAA. So we know that in the medical device manufacturer, pharmaceutical space, many of these organizations and our organizations are not directly regulated by HIPAA, and therefore someone steps in, and that's typically the FTC at the federal level. So in this particular case, we have an FTC order, and Cerebral is a kind of a mental health wellness organization that's focused on supporting these, through apps and through services, mental health. And additionally, a part of that is collecting large volumes of information related to mental health, which of course is sensitive, and the FTC is concerned about how that's protected and maintained. But the complaint that the FTC filed alleged that there were several privacy violations in terms of how that information was used and shared, and really focused in on some tools that were used on the Cerebral website and through their apps that led to sharing of sensitive information with these different kind of tracking tools through LinkedIn, through I think it's Facebook and or Snapchat and TikTok. So a few different tools that really, because of the way they're embedded on the web page or in the app, can share large volumes of data with third parties. And of course, that on its own, is not a great situation. But then there was also not consent or a significant awareness or acknowledgement of this within the privacy notices, and no explicit consent given for that sharing. Here, nearly 3 million affected, consumers affected by that. And so the the settlement was around $7 million, which kind of reflects the volume of data and impact of this one. I think one other thing to note here that I highlighted in this slide is that the FTC didn't just go through the settlement side and require a privacy program, kind of the standard FTC approach, but they also added a ban on certain sharing as part of their, particularly with marketing, for marketing purposes, as part of their enforcement activity. Another kind of similar situation, Monument Health is a provider of services, particularly for those with addiction issues related to alcohol or other particular drugs. So there was a similar concern, again, that ad-based sharing or ad tech-based sharing of what, let's say you visited the website and you used their services, certain data from that was being shared with third parties like Meta or other advertisers. And a part of that was they had these sort of like session IDs or ways of identifying the purpose of the visit, which disclosed certain information about that individual's health. So it could be that they had a visit or that they paid for healthcare on that visit to the website. So each website visit would be linked to this, not only identifier, but also what their service they were seeking on the website. And so the FTC took issue with that. And eventually, as of June of last year, there was a $2.5 million settlement that resulted from this. Again, another online wellness provider. And I think helpful just to frame this, while these are not med device or pharmaceutical companies directly, this is the kind of activity that the FTC is looking at in terms of health information, where it's shared, the kinds of trackers on websites that are implemented, other sharing of data. And so here's another example of that. So BetterHelp, if you're familiar with BetterHelp, it's a mental health wellness kind of online therapy service where you can be connected to a therapy provider through the web app or through the mobile app. So here the issue again was that there was a certain amount of sharing, again for advertising purposes, that BetterHelp was engaged in, which the FTC again took issue with because they weren't disclosing it and getting consent from the users whose information was shared. So again, sensitive information about health and wellness and mental health was being shared with these ad tech companies. And kind of in critically to this, a lot of times when this sharing occurs, if you're the company that's sharing it, you're thinking, well, look, Facebook or Google, they're promising us that when this data is shared, it's hashed, it's anonymized. We have no idea who it is. We're just using that data to help target to kind of a broad audience that fits these markers that might be in your data. But the reality is the FTC looks at that and says, well, hashing really isn't anonymized data. It's a way of reducing identifiability, but it's not necessarily anonymous data. And in many cases, the data would be provided to the ad tech service provider and then hashed. So there's often kind of an initial disclosure that's not protected at all, and then the hashing is a subsequent activity. But either way, the FTC has been concerned that, look, this isn't really an anonymization of data. And so this is a sharing that could be problematic. So one of the key things here too, and I think it's highlighted on this slide, is not only is the FTC concerned about kind of unfair practices, which are those that are generally not expected or kind of out of the norm from what a consumer might expect, but also promises. So if you have a website that says HIPAA compliant, or we keep your information private, we never share it without your consent, or you have these kinds of broad statements, or even specific promises that are very close to what you do but aren't exactly correct. The FTC is going to look at those and say, well, you promised those consumers that you wouldn't share this, or that you would keep their information private, or that your security was at this level and perhaps it was at this lower level. So whenever those kinds of promises are out there, you could find yourself in a deceptive trade practice scenario where your approach to that data and how you handle it doesn't actually match your words, and that is also a concern. So I keep skipping here. So we've got state enforcement trends. So we'll talk through a few of these. Mostly this is focused on California, but we do have a new, kind of a newer law in Washington that we'll look at as well. So again, a key focus area of these enforcement cases has been adtech. And that's not to say that adtech is the only issue, but it is a prominent concern, and largely because health information shared for adtech is not controlled well in the way that most other kinds of service provider data is protected. It's shared and then usually reused for various purposes by the adtech organization. So there's a major focus on that. But there's a lot of different avenues for this kind of sharing to occur. Here's another example of that. So Tilting Point Media is a company that develops games and apps. If you could analogize this, think about apps that you might develop in the healthcare space, whether it's to track patient outcomes, ePro, or it's something along those lines, or even maybe it's a patient-directed app that collects PHI or even personal data that's related to a drug or therapy or implanted medical device, different things that might be similar. So the development of those products really needs to keep in mind what kind of data is collected and how is it shared? Are there third parties involved? And these kinds of cases can be illustrative of issues that might come up. So in this case, we had a significant settlement from the Attorney General of California, responsible for enforcing the CCPA, the California Consumer Protection Act, and they looked into particularly how is this game developer and this app, how is it interacting with children's data in particular? Again, children's data is a major area of focus for enforcement for obvious reasons. And so they were concerned about some of this. So one of the focal areas is how is the software in this app, it was configured. Ultimately, it was configured in a way that didn't clarify the age of individuals and whose data was being collected properly, at least according to the Attorney General. And then when they looked closely at it, they found that data was being shared with third parties through the app in ways that weren't disclosed clearly or even consented to. Additionally, if you have a minor child who's engaged in the app and using the app, they may not even have the ability to give consent to sharing. They made it a parent involved. So there's kind of additional issues when a child's data is involved in the enforcement. And I won't lean too much into this one, but suffice it to say, California has been active in enforcement on privacy. So DoorDash as well. We have a highlight there. I want to spend a little bit more time focused on the Washington My Health, My Data Act. So uniquely, there are many state laws that address privacy, but very few that give consumers the ability to directly enforce those laws. For the most part, even HIPAA and in the Federal Trade Commission Act are enforced by government agents. So it's whether it's the Attorney General or whether it's the FTC, it's different enforcement bodies at the government level. But Washington has a privacy rule that's applied to consumer health data. That's a pretty broad definition, but it largely addresses any information that's collected about consumers within the state and then processed and handled. So this rule grants to any individual who's been, if there's a violation of that law, the right to pursue under the Consumer Protection Act in Washington independently and on their own a enforcement action. And so that's what happened recently. And the focus of this was Amazon because they have produced a number of different software elements, but one of them is a software developer kit, and that was used in a lot of different apps across app stores of different kinds. And included in that software development kit was certain data collection that relates to geographic location as part of that kit. And so by default, anyone who's using and deploying an app using that kit could be and would be collecting location information about individuals. Well, the argument in this case is that, certainly location alone might not be consumer health data. It can infer health information, like what if you visited a hospital or a particular provider, or and especially as you start thinking about specialized providers that maybe offer a unique service, there's more and more potential conclusions that could be drawn from that data. And so that's what the basis of this suit is. We'll kind of see how that plays out. It's in the midst of kind of early stages here. So some other enforcement, we'll look at GDPR. I think that's also very relevant to the med device space and pharmaceutical space. We have a few big cases, I think these tend to draw the most attention, those that get into the hundreds of millions. And so we'll talk briefly about these. Meta is one example. And so Meta's been the subject of a number of these enforcement actions, usually through Ireland because that's where their kind of European offices are. But we'll see that a major focus of these kinds of actions is usually things like lawful basis, the use of information internally and whether that's appropriate. There might be a lack of disclosure about what information is being used and the basis for that. Because GDPR is focused not only on security of information, but how do you use it internally, how do you share it, and is that all aligned with a really pretty strict framework around kind of justifying the use and disclosure of certain data. So that a focus on these two actions here is a privacy breach. So in one case, there was a breach that impacted 29 million users. And the focus there was kind of insufficient protection of passwords. What I find interesting about this is it was an internal breach. So there wasn't actually disclosure of any data outside the company, at least that was identified in this investigation. However, this apparently 29 million individuals' passwords was stored in this server, and it wasn't encrypted. And so the mere fact that the data was available to others within the company and not protected appropriately that way, the DPC, or the Data Protection Commission of Ireland, considered that alone to be a reportable breach, not just a security incident, as we might kind of typically think of these internal issues, but a breach that should have been reported to the government. And so they, of course, cited failures to properly implement data protection impact assessment and address and identify this issue. Another one here is LinkedIn. As you know, probably know a Microsoft company. So again, a large tech organization. And this fine was based on an insufficient legal basis for processing. So as we've noted before, processing is largely the use or disclosure or handling of data. So collecting information is processing. If you process or analyze it in some way, that's a form of processing. If internally you grant access to someone, that's a form of processing. So it's a very broad definition, includes storage, maintenance, all of these things. Within this case particularly, there's a focus on insufficient consent. So if there's a use, in this case for behavioral analysis, identifying maybe some user tendencies, and then advertising targeted to those users, those would be processing activities. So then essentially under GDPR, LinkedIn would have had to identify certain bases, whether that's, hey, our legitimate interest to use this data for business purposes, in this case, advertising, outweighs the individual rights of this data subject. Therefore, we have a legitimate interest to use this. That's kind of the legitimate interest analysis. On the other hand, there could be a failure to get consent. So let's say they said, well, you don't actually have a legitimate interest, which happened in this case. So you needed consent to do this processing, this behavioral focused advertising, and therefore violation. So that's really the focus in this case, is use of data within LinkedIn that the Data Protection Commission identified as lacking. You didn't pick the right basis, therefore you didn't have consent when you really needed it. And then a few examples from medtech I think will be helpful to kind of frame this better. So a few different fines that I identified through some research. And if you go online and look for GDPR enforcement trends, there's well over 2,000 fines or penalties that have been issued over the past several years of enforcement. Most of them smaller, and some of these are kind of middle of the road, but you can kind of see that there is active enforcement. And it's not surprising if you think about how many enforcement bodies there are across the European Union. There's 23 alone in Germany, and then there's individual oversight within each member country. So there's quite a bit of focus on enforcement. So these are just a few examples of many, many enforcement actions. In one case here, Argon Medical Devices, there was a 220,000 euro fine, and the focus of this was a failure to notify quickly enough when there was a breach of the employees' data within the company. And so GDPR requires 72-hour notice to the data protection authorities when there's a breach, and that didn't happen in time in this case. In this medical lab case, 20,000 euro fine, so a smaller fine, but the focus of this was data protection impact assessment. And so really something pretty basic, looking at a processing activity, something related to personal data, and then identifying that they really didn't assess this activity properly. And therefore, also missed some other kind of basic compliance elements. And then MedHelp AB, this was a larger fine, 1.2 million euros. And this was focused on a telephone hotline. It was essentially a company that provided medical consultation through phone. And one of their service providers had a breach. And the breach, bubbled up. They had to report it. But eventually, it ended up being found by the Data Protection Commission or Data Protection Authority that this particular company had contracted this to a third party, but failed to adequately vet that company, ensure that there was security in place for the data, and then also lacked the right kind of agreements and controls to make sure that those same protections in, I believe this was Sweden, in Sweden, were transferred properly to that third party company. So again, focus on these kind of areas as you're developing your compliance programs. So within all of these, there's kind of a key theme. We have these data protection programs and privacy programs that are needed to establish the framework. From the very beginning, the FTC is looking at, okay, what kind of data use is going on and sharing, what's collected? Are there controls around that are adequate? And so each of those FTC enforcement actions, each of those HIPAA compliance enforcement actions, each of the GDPR enforcement actions are all looking at what is in place at the company and requiring, in many cases, that something be implemented. And it's pretty robust. If you look at some of these complaints and how the settlements eventually shake out, there's pages of requirements for these companies to implement a privacy and cybersecurity program. And then if you're doing processing, especially in Europe, but even in the US, do impact assessments or security risk assessments or both that focus on how is the data processed, what kind of security controls are in place around it, and then develop accordingly so that you're addressing those risks. And then lastly, look really closely at your plans around security and how do you address incidents. If there is a security incident, how do you respond? Will you timely address it? A couple of these were related to failures to notify or delays in notifying, whether it's HHS, if it's a HIPAA violation, or the local authority under GDPR. So be prepared for those. And then lastly, look at your third parties. A number of these breaches, and most breaches seem to occur through a third party failure. So have vetting processes and have good agreements in place to protect the company in case there is a breach. So I think I'm all done with the presentation. If there's any questions, I think I'll take those later when we have a chance to discuss, or feel free to shoot me an email as well. All right, thanks everyone.